Greetings, Derek DeBrosse, Ohio gun lawyer here, coming to you from Munitions Law Group, munitionsgroup.com. Look us up on Facebook, LinkedIn, as well as Instagram. We're trying to get Instagram up and running a little bit more. I'm coming to you from Columbus, Ohio today with some good news and not so new good news regarding Ohio House Bill 228. Before I get to that, I wanted to just drop a plug that we have gotten my law partner Clay more involved in the YouTube channel. You'll see his face a lot more, which will probably be pleasant to the subscribers. He's a lot more handsome than I am. Clay will be talking a lot more about the industry side of our practice. He recently appeared with a good friend of ours, Iraq veteran 8888, on his channel on his Gun Gripe segment. So check him out, follow us. There's some good information. Let your dealers, manufacturers know that we are out there putting the information out as much as we can. With that said, today is all about House Bill 228. I had a video up earlier and I had to take it down. And the reason why is I discovered through discussions with some of my colleagues, friends, activists in the community, as well as my reading of the law, that there is an inadvertent clerical error. And I want to jump right to that one first. And that's 2923.11, the weapons control definition section of the House Bill 228 of the revised code. And what it attempted to do, was make certain shotguns legitimate and legal that are not currently legal in Ohio, which are legal under federal law. And that is your firearms, such as the Mossberg Shockwave, with the different type of grip that looks like a short bullet shotgun. The barrel is actually 14 inches. The overall length is, I think, right around 26.3. But in Ohio law, those are still considered what we call dangerous ordnance, and they're generally illegal in Ohio. All dangerous ordnance is, unless you get a license from the sheriff, which is not mandatory for him to issue or her to issue. So it became a huge burden on the citizens of Ohio, and a lot of my dealer clients would call me and wonder if they could sell these things because they were getting them in stock. So they are currently illegal in Ohio, and even after this law takes effect, unless something happens until then, if we get an emergency legislation passed, it will still be illegal. Let me explain that. So when they changed the law, in the original versions of it, they changed the definition of sawed-off firearm, because sawed-off firearms are considered dangerous ordnance. In the definition of sawed-off firearm now, the Mossberg Shockwaves, and I'm just going to use that term as a general term for these types of shotguns, basically were carved out of that definition. That stands true under the law as passed. However, what they did do inadvertently is in one of the final revisions that took effect, they took a section of the revised code that says these things are not dangerous ordnance, and they had that definition in there to further clarify it was not dangerous ordnance, and inadvertently put it into the section right above it in the K section that said these things are dangerous ordnance. So these things are dangerous ordnance even after this law takes effect. They're no longer short-barreled firearms or sawed-off firearms, but they are still, in and of themselves, by that definition, considered dangerous ordnance. So they will still be illegal. I do know that the General Assembly and the activists are talking about making an emergency passage of legislation or making it a priority in the new term. So make sure you call your representatives to stress that to them. So moving on, we'll get into the rest of the laws. If there's any questions on that, please call us, drop us a line. Oh, one other thing about that, there is some speculation that maybe the way it was drafted would make certain types of firearms like the AR platforms and AK platforms illegal. That may be true. I haven't fully analyzed it yet, so stay tuned. I'll keep you updated as much as I can. But obviously this was a clerical error and we're working to fix it. So moving on to the rest of the law. First thing I want to talk about is how it passed. Governor Kasich did veto this. He was not happy. He didn't get what he wanted, blamed the gun owners and refused to sign it. However, we overrode that veto. So please thank your congressman. They need to hear from you. Also thank Ohioans for Concealed Carry Buckeye Farms Association, as well as the National Rifle Association. They worked tirelessly to get this thing passed. All right, I'm going to jump in and just kind of go through the various areas of laws that did change or were newly implemented. I have drafted a chart you'll find on our Facebook page. Please like us on Facebook. That will give you a summary law and point in the right direction to where those laws are at. 9.6a is what we commonly refer to as preemption. That was further enhanced, I would say. I have filed many lawsuits over the years against municipalities, cities, villages that have illegal laws on the books, such as pay $50 to your sheriff if you want to sell a firearm to your friend, that type of thing. And we have sued and won, I believe, all those cases that we've actually filed, we have won. We've beaten Cleveland up twice, I believe. City of Oberlin, Cleveland Heights, there's various other cities that have been involved in lawsuits. However, what the new law basically does is it broadens the breadth of the protections regarding the Second Amendment. What I can possess, how I transfer it, how I keep it, what ammunition I can possess, things like that. It uses additional legal language to further broaden it. And the biggest thing it does is it ensures the attorney's fees will get paid on anybody that actually files a lawsuit. What would happen many times is the municipalities or villages or cities would change the law halfway through the litigation and say, you're no longer a party that prevails in a challenge because we haven't gotten to trial yet. And sometimes courts would agree with that, and more often than not, we would normally settle out of court because it was a little bit unclear. So now we have made it exceptionally clear that those fees get paid even if you don't get it to a trier of fact. Even if the lawsuit's not filed, attorney's fees will get paid if there's a challenge to that illegal law. There was a new section created 9.69, and in conjunction with 2923.121, the law enacts provisions when an officer is on duty and responsible for enforcing all or certain laws, and it clarifies the responsibilities and applicabilities of laws regarding law enforcement officers and alcohol establishments. 109.801 and 307.93 provides for training and allowance of certain multi-county correctional officers to carry firearms while on duty. And then the big kahuna, 2901.05. Before Stand Your Ground was stripped from House Bill 228, after it was stripped from 228, this became one of the sole focuses of this law. And what it does in a nutshell is it changes the burden of persuasion from the accused and puts it squarely on the government where I believe it should be. Now, for many years, Ohio is the only state that has the burden of persuasion on the accused. It's called the Ohio exception. So the way the law currently stands is the burden of production is on the accused, and it will remain on the accused to show in the record that there is some sort of evidence that could lead a trier of fact to believe there was self-defense deadly force, or the accused could testify on the stand to meet that burden him or herself. Then the burden of persuasion would be on the accused currently to prove to a preponderance of the evidence the three elements of self-defense deadly force. What this law does is it changes that. The burden of persuasion is now put squarely on the government to disprove self-defense deadly force beyond all reasonable doubt, bringing it in line with all the other states. Our good friend in Colorado, Andrew Bronca, who writes prolifically on the Second Amendment and has his own blog, wrote on an issue recently on illegalinsurrection.com where the burden of production can become a catch-22 for the accused, wherein if there's nothing in the record showing self-defense, they may have to take the stand to testify their state of mind and why they believe self-defense deadly force was what they needed to do to take a life. That can put the accused in a kind of a quandary because they're taking the stand, they're testifying, it could end up hurting them. His studies have shown that generally is almost always inevitably a bad guy with a gun who doesn't have a good shoot, essentially, so to speak. I do have some friends that are in the legal community that believe that it's going to be more harmful to the concealed carry community than it's going to be helpful. I disagree with that. I think 49 other states have been doing this for very, very long. I've talked to Mr. Bronco as well, and there's just not a pattern where that's occurred, where a good guy with a gun ends up incriminating himself to a crime because he has to meet his burden of production. But all in all, what the law does is it puts more of the burden on the government, and that's what you, the viewer, should understand. Moving on to 2923.11, we already discussed that. Again, that's the Shockwave issue. And then in 307.932, 2923.1212, 1214, and 126, signs and identification. Essentially, all this law or amendment did was simplify what entities must post no gun signs and how and where they get posted. And the big thing it did, in my opinion, was eliminated the need for two forms of identification. One, your concealed handgun license, and another form of government identification. It was superfluous, it was redundant. The CHL itself is government identification, so that is all you'll need to carry when this law takes effect. It also clarified law enforcement rights to carry concealed handguns. 29, 23, 18, and 20, unlawful transaction of weapons, really brought state law in alignment with federal law. Federal law has clear criminal violations for what we call straw purchases, whereas if you give me money to buy a firearm and run a background check on myself, wherein I give you the gun afterwards, that's illegal. That's a federal felony. That's a straw purchase. That will now be a crime under state law and similar types of conduct such as that. It also provides for certain exceptions for law enforcement officers regarding those types of crimes. And then lastly, 2923.129, immunity of law enforcement officers, repealed certain protections in the revised code if a law enforcement officer uses his or her firearm while off duty, leading to injury or death. I hope that answers any questions, uncertainties, unclarity that you may have regarding House Bill 228. I will get that chart that I've created posted on Facebook. Like us, follow us. Drop a line if you have any questions. Shoot us an email. We'll be sure to put it in the queue and try to get it to our filmographer. Make sure we get it on one of our next episodes. And as always, remember to be safe and carry on.